Hi, everyone. Welcome to episode 195 of the Immigration Lawyers Podcast live. It's Friday night from Woodland Hills, California, and showing my dedication to the practice of law at 9 p.m. We're not going out, we're not partying. I'm a dad, so just settling in and trying to use the few hours when the kids are asleep and do some work. It's May 25th, Friday, and this is something I like doing this kind of episodes because I talk about things I learned about law or things I don't know answers to, whatever. But if you're an immigration practitioner thinking about getting into immigration, this is definitely the kind of podcast you need to be listening to because these are the issues that after 11 years are still popping up and you got to think about, and they're so new and all this kind of stuff. Before we start, I want to remind everybody, please check out the Immigration Lawyers Toolbox magazine. Issue 2 is out. You're going to love it. Colleagues really outdid themselves, the articles they wrote. I mean, this is a game changer in the immigration field. Promoting so many different lawyers who don't get the attention they deserve, getting the education knowledge out on all these different topics. I'm really blessed to have the opportunity to be able to produce this. And I also want to thank the sponsors who make it possible, in particular, DACA, who's always been a supporter of the podcast and the magazine. If you go to DACAwise.com/immigration-lawyers-podcast and type in the code Immigration Lawyers Podcast, lawyers is plural, you'll get extra 10% off your annual plan and have a great program there. You can probably test it out first too before getting started on it, so you can see how it could help manage your office, not just the forms, which they update frequently, but all the other systems they have in place. That's going to be really helpful. And if you're watching live, which we're recording this live, feel free to leave a comment. I also want to thank the other sponsors that are part of the magazine, in particular Visa Business Plans. Visa Business Plans with Marco Scanu at the head. We're going to be interviewing him, I think, on Monday or Tuesday coming up, about how his operation works and what he does and how people can take advantage and use his services for immigration business plans. And interestingly, he was talking when we first talked, he was saying, because the next issue is going to be an O1A focused issue. And he's like, we do business plans for O1s because these entrepreneurs come. So that is a very interesting thing to think like, oh, maybe have a business plan for an O1. So that's something it's gonna be fun. We're gonna talk about that, but also he's gonna probably have an article. I'll talk with him about it. Other than that, what else we need to mention before we get into it? So there's magazine. We got great sponsors, and if you are, there's other stuff, but just email me at info@immigrationlawyerstoolbox.com if you have questions. One thing I'm trying to maybe do, I get a lot of people contacting me about the community I've developed and about marketing and business, not just the legal stuff. I was thinking about doing an hour call once a month to talk about how I do different marketing things, how I use social media online. If I get enough people signed up, if 5 to 10 people come in, I'll probably set that up. So if you're interested, take things to the next level, just email me at info@immigrationlawyerstoolbox.com, and I'll talk about the program, see if it suits you, if it's appropriate for you to be part of it. And if I get enough people, we'll do a call to share that information to help everybody out. So with that, let's get it started. A disclaimer, this is not intended for individual legal advice. Every case is different and may be wrong in the things I'm saying, but these are some stuff I picked up in the last week or two that I wanted to mention. All right, so first off, this is weird scenario that pops up, and weird is a loaded term, but it's a not typical kind of scenario. You have a person here on a student visa, tourist visa, or whatever kind of non-immigrant visa that doesn't have work authorization, and they say, I need to make some money. In this scenario, it's a female, and they donate their eggs or they carry someone else's baby and they get paid for it while they're here. And so it's not a typical situation, but you got to keep in mind, like egg donation from all this kind of stuff can be considered unauthorized employment. If you're in the United States, you're getting paid for doing some work. I mean, it's kind of the same, carrying someone's baby or donating eggs. It could be, work for that. So I got a call from a person who was denied entry and given expedited removal because when they searched their phone, they saw that they were an egg donor, and CBP at that port of entry said that that's unauthorized employment. And so they got expedited removal and they're stuck with that. So I had got a couple came to me about a couple of years ago and asked about this. And I'm like, I don't know. I would, I would not go towards that because I would avoid it because, it's an unknown thing if that's going to be a problem, but it was in this case. And one thing I forgot to mention, going back to, some housekeeping stuff, I'm going to be talking, I'm going to be on a seminar for the Rome District for AILA on June 2nd, 1 p.m. Pacific. We're going to talk about tips about how to run your business and all this kind of stuff with a great panel. And also at the AILA conference, I'm in a panel called Up Your Game, New Marketing Techniques for 2021. This is on June 9th. I don't know what time it's going to be, but just check it out, June 9th. I'm with the All-Star panel there as well, so you can check those out. So the egg donation was one I wanted to mention. It's an interesting thing that pops up, and that's going to be like random 10 or 11 random stuff have nothing to do with each other. I'm going to mention here. Thank you so much. We got a Facebook user that says great stuff, love your content. Thank you. Unfortunately, software doesn't tell me who the person is if you're on Facebook commenting, so feel free to write your name after them, but I appreciate it. I have a guess who it is. Someone maybe in New York, but they should be sleeping. It's too late for that, but if someone else, let me know. So I have a client, we filed an I-130, a U.S. citizen petitioner filed an I-130 spouse. After filing, the poor guy gets diagnosed with cancer, has some surgery, chemo, the disaster that is cancer. And so we just got the filing receipts in the same time. He did the blood test, got diagnosed, and now he's getting into it. So I immediately, did an expedite request for USCIS, urging humanitarian needs, saying, this guy needs to have his wife here. Let's expedite this process. I was thinking it's an open and shut case. We got the evidence. He went and had to pay his doctor for extra notes, which is kind of weird, extra letter for explaining it. But whatever, he paid it, did it. And, you call USCIS, request to expedite. Normally within a week, they email us and they say, please send us evidence, please email evidence to this email address, blah, blah, blah. And I say, okay, we do that. And then, it gets approved. I called in the expedite. 3 days later, I got an email saying the expedite's denied at the time, even asking for evidence. And so that was really, really shocking how callous really could be in this kind of situation that they can't expedite this case for this guy who had cancer. So we're reaching out to a senator right now to see if they could help out and push this issue, because it's pretty ridiculous. I'm not sure if the ombudsman could help with this if we go down that route, but I mean, come on, this guy's life is on the line and want to have a spouse here during this troubling time. So when you have clients ask, well, how can we expedite? Like everyone's talking about expedites all the time. There's people that do videos on YouTube and stuff saying this is how you expedite this and that. Give it with a grain of salt. Unfortunately, this expedite situation is not like guaranteed. I would never thought this case would not be expedited. I thought it would have been accepted. So be careful. That's the way it is. All right. Another thing, clients missing notices. So I got this consultation with a person who missed an RFE. RFE led to denial, and they didn't get the RFE or the denial. And then 3 years later, this was a sibling case, or like one of those cases, family-based, that takes like 10 or 15 years. Years later, like, oh my God, like we're denied this and that. They're freaking out. I'm like, yeah, you're out of luck. And it really comes down to this. You hire a lawyer for a family-based case, especially for a preference category that's going to be, F1, F3, F4 category. So your lawyer gets an additional copy of everything that's there. It might seem like a waste of money because I want 30 for a sibling case aside, and I'm preaching to the choir who's listening here. But that family who was waiting 10 years that got wasted, I bet they would have paid $10,000 for the lawyer to have gotten notice, just to let them know, hey, we got notice too. Now it could be the lawyer moves. I mean, there's no responsibility necessarily, and I contracted out to say after we file, I'm not responsible. But eventually, I'll get the notice, and I'll probably give it to them if it was me. So when you talk to clients, I always mention to them that the value in the lawyer comes with just being able to call them and be able to have a G20 on record, and the G20 giving permission for them to get an extra copy of everything. Because all the time clients move, or even if they don't move, the post office loses it, puts it in the wrong place, all this kind of stuff. So this is really important aspect of it that clients should be aware of. It seems benign, it seems unnecessary, but that's how life works. Now I had another call / consultation with a guy. He wanted to do asylum in the United States because he was, his home country was a problem. And so he came here, filed for asylum, but to get here, he had to file for a tourist visa. And he worked with some group that helped him, like fraudulent marriage documents to say he's married. And then this other woman who was also going to commit asylum, file for asylum once they entered the United States. Both of them went to the interview, said they were married, got the tourist visa, and came. And one thing that caught me off guard is, like, why would a tourist visa become more likely if you're married and you're coming with your spouse? I mean, what difference does that make? But apparently it worked for the couple. This is the country that they're from that has a high denial rate for tourist visas. But they both came, and then once here, they didn't know each other, really weren't married. So they just went about their own way, filed for asylum in a timely fashion, and the case is pending. Asylum cases take years sometimes. In the meantime, guy falls in love with the U.S. citizen, files for adjustment, and says, hey, I committed fraud here. Now, the lawyer they had didn't even submit a waiver with it for the fraud waiver. They waited for the interview. But the interview was denied, and not necessarily for the fraud, but I-130 basically was denied, saying you're already married, so proof that the second marriage is valid. And the guy was like, hey, this was a fraudulent marriage. And this made up documents. We're never married. I didn't even know this person. But they're like, no, on the record for us, you're married. You have to prove you were single when you got married to the U.S. citizen that you're filing for. And then you could try to do the I-130 and all that kind of stuff. So, he probably has to get a single certificate from his home country, all this kind of stuff. The problem is he's an asylee, doesn't want to go back to home country. He was freaking out about that. It's just something to be mindful of. Don't file one of these if they have fake marriage. You got to do a waiver, but also get the certificate that shows the marriage is fake in some way before moving the case forward, because they will deny the I-130 in these kind of scenarios. All right, number 4, passport validity. Number 5. So one thing you have to be mindful of is when someone's being admitted into the United States on a non-immigrant visa, the passport has to be valid for more than 6 months from the intended departure date. I think it really is. So let's say you're coming with a tourist visa and it's going to be 6 months. You need to have a passport that's valid for additional 6 months. Now, some countries, and this is really important to know, if you check out the Foreign Affairs Manual for the Department of State, some countries get an automatic 6 months extension on their passport beyond the expiration date. There's a list of the countries that this applies to. But let's say you come in, you have a passport that only has 3 months on it, and you're from one of these countries that's the extra 6 months, they'll only issue the B2 for 3 months when you're coming admission. Well, they're supposed to. If you're coming from one of these countries that doesn't have the automatic 6 months, they could potentially, they'll probably let you in, but they could deny you admission, saying you don't have passport validity according to the CFR regulations, all that kind of stuff. So that's that. You got to be mindful of that. The problem really pops up for admission is people with H-1B visas come in, the passport's about to expire in a month, so the validity of the I-94 only becomes 1 month, but they don't notice that because they think, the approval date for the H-1B is for a year, 2 years, whatever, left on it, so it's all good, and then they get stuck with this later. They have to file a non-proton extension request, all this kind of stuff, which I'm not going to talk about right now. But I had the misunderstanding. I thought this also applied when you do an extension of status for some reason. So it doesn't apply for extension of status. You just have to have a valid passport at the time of filing for extension of status, or change of status even. But the having the validity for that whole time and limiting your I-94 time is at admission, but not when you're in the United States. So it'll give you the full time as long as the passport is valid at the time of filing. And I remember reading somewhere that you have to maintain a valid passport in the United States, which has gotten really hard because of COVID, because a lot of embassies won't be renewing passports or shut down this and that. I'm sure USCIS will give special occasion on these to not be as strict, but be mindful of these nuances. It's just a gazillion different nuances with immigration that you got to be careful of and always think about. So it's so important. Now, another thing is the I-407. This is when someone wants to abandon their green card, not have it anymore. Now, sometimes someone, has a green card, they've been out for 10 years, they don't want it anymore, but then they want to come back and they may have like a U.S. citizen child. The U.S. citizen child wants to refile an I-130 for him. Do you need to, affirmatively abandon the green card and file an I-407? Well, I've done this where we didn't need to, because there's the automatic assumption of abandonment once you're out for more than a year, I think it is. So it's not mandatory, but nowadays I would do it to be safe. Now, a colleague sent a Foreign Affairs Manual, section 9FAM 202.2-4C, and it says, there's no legal restriction preventing an LPR from obtaining another immigrant visa in a different preference category. Okay, I'll read that. That's an interesting thing. But essentially, the FAM kind of says you don't have to get a new visa. You don't have to abandon the old one to get a new one. They could assume it. But nowadays, it's safer to do it. I haven't filed one. I'm going to be filing I-407 pretty soon the first time. I remember 2 or 3 years ago, one of our colleagues in Washington State, his name, he does a lot of lawsuits, Jay Garrick, told me he filed an I-407 because they updated how the 407 works. You have to mail it into like a lockbox location of some sort, and they kept returning it, saying it's not valid. Previously, people would try to go through the CBP port to do it, or see embassies accept it. So what I'm going to do is mail it in according to the I-407 new instructions and see what happens. But be prepared for that kind of stuff. Ideally, you never want to file an I-407. But in that note, I referenced 9FAM 202.4C. It says there's no legal restriction preventing a LPR from obtaining another immigrant visa in a different preference status in order to confer derivative status on a spouse or child There's also no requirement that the alien resident abandon his LPR status. So what does this mean? So let's say you have a green card, but you want your spouse and kid to get it. So you file for another work visa, and then the kid and spouse could get in on that and could come in. It's kind of a weird situation. I'm not sure where this would come up, but that's it's there. It's family. You read it. So again, I'll read it. There's no legal restriction preventing an LPR green card holder from obtaining another immigrant visa in a different preference category in order to confer derivative status on a spouse or child. There is also no requirement that the alien resident abandon his LPR status. So whether they're going to get another green card because the principal has to get another immigrant visa and do landed entry before it goes to the spouse and child. So that's that. I use this word landed entry, landed immigrant. My wife was watching a TV show yesterday, and she's like, they're talking about immigration. They keep calling about landing immigrants. And landing immigrant is a term that Canadian immigration uses, not the U.S. immigration. And so I was like, why are they using that? But they have something like that. Landed immigrants is a Canadian thing. It's like if you're a green card in Canada. So that's a term. So be careful. Not careful. Who knows with the I-407? But ideally, you never want to deal with that if you don't have to. All right. So another thing, a colleague of ours who's on LinkedIn, I think one of the best LinkedIn posters. He has some very insightful stuff. If you are on LinkedIn, you should definitely join in. I forgot his name, so I went on LinkedIn, and obviously the first one he always posts is is Robert Weber, and so he actually has an interesting thing. I was posted. I wasn't planning on talking about this, but he's talking about adjustment of status and the birth certificate satisfying him. And I think I got an RFE for 2 Indians right now, and we work really hard to adjust and prepare for the birth certificate issue because they had problems. But we got an RFE. I haven't read it yet. I'm assuming that's it. But we had every single document you're supposed to have. So hopefully it's not a bad RFE. But he's talking about how difficult Indians are. I have another case I got today where the first name's not on there. He fixed it up. But Indian birth certificates, a lot of times, going to be a major issue. But he had posted something that said if you're going to do an 01 extension, extensions are 1 year. Now, I don't do 01, I just want to mention this. But, you do extension of status, you can still be in the United States, not have to travel, which may be worth it right now because the embassies, a lot of them are not doing non-immigrant visas. But let's say it wasn't the case. If you do an extension for 01s are 1 year at a time. But if you do like new employment and then you do consular processing, you get 36 months, 3 years, and I have to keep redoing it. So I guess if you get an itinerary that long, that's the thing to do and to be careful of. But one thing is when I say 36 months, you got to check the reciprocity chart because it varies a lot. Like E2 visas in particular, the visa reciprocity chart is a page on the Department of State website that lists nuances of how a civil document is supposed to be obtained or to look like for a foreign country, but also their visa categories, in particular visa reciprocity reference the fact that other countries get visas for us and we give it to them and we want to match it. And you got to see what matches. For example, if you're looking at an E2 visa for Bangladesh, you can only use it twice. It's a 2-time entry, and the validity period is for 3 months. So if someone is going to do the E2 visa from Bangladesh, it kind of sucks because they're going to be stuck here every time they leave. They probably have to get a new visa. However, if you go, let me look up a European country, Australia, they changed it. So for Australia, the E2 is 48 months, so it's not bad. 48 months. It should be, I think, 5 years. But what really sucks about Australia, you got to check this out, is the per application visa fee, visa reciprocity fee, is in addition to the application fee for a visa, is $3,574. So if you have a family of 4 doing the E2 from Australia, they're going to have to end up paying 4 times that. Do we do the math really quickly? Let's see, 3, 6, 9, 12, add 2,000, $14,000. Now, do we have to pay a visa reciprocity fee if you're doing extension of status or something like that? I don't think so. Do we? Yeah, because you're not. Let's see, what have I done? These new fees came after I really stopped doing E2s, so I haven't dealt with it. But do you have to pay the visa reciprocity fee if you're doing it in the United States? I don't think so, because I had a Chinese client, and I usually always do extension or change of status for changes for L1s, and he had to go to get a visa. They charged him an extra fee after they approved it. I was like, what the hell? Why did they charge an extra fee? And that's when I got familiar with the visa reciprocity chart and the extra fee. So for China, like for an L1, you got to pay an extra $120 per person. So yeah, we never do that in the United States. So yeah, if you're going to do Australian, you're going to want to do extension of status, but it's only 2 years. They'll make up for the price by paying your lawyer to refile after 2 years. All right. So, what else is next after spending a lot of time on that one? How are we doing on time? Okay, we're going. All right. So, next thing is this. I don't know the answer to, and I'm getting mixed stuff. I can't find the rules to. So, let's say you want to file an I-131 reentry permit. The rule is clear on that. It's in the 8 CFR. It says if you're going to file a reentry permit to physically be in the United States. Okay, that's easy enough. If you're going to file an I-539 extension of status, change of status, obviously you have to be in the United States. That's easy enough. What about an I-90, a green card renewal? Well, I'm pretty sure there's no requirement to physically be in the United States for the I-90. And for N-400, I filed them, I believe, where the person was in the United States, but I always file by paper. And someone had posted that, could you file when you're overseas? And there was answers that said, no, if you're going to e-file, you have to be in the United States when you're e-filing an N-400 application. You can't do it from abroad. But it leaves it open if you do it by mail if the person's abroad. And I couldn't find anything in the statute that requires a person to physically be here for an N-400, whether e-filing or by paper. And the statute probably wouldn't have it. It would be in the regulations. But I couldn't find anything that a statute may have it. But I couldn't find that. So if you're listening, you know for sure what the answer is. Two colleagues said for sure e-filing you can't do. But one colleague said I went online. The only website that directly references without citation was one of these self-help filing kind of websites that help you self-file. So, what's the answer? I don't know. But, ideally, a client won't be overseas when you're filing. A big issue, a big issue that kind of reference with the O1 thing I talked about is third country visa processing for non-immigrant visas. It's a nightmare because, I'm going to talk about this. It came out today or yesterday, the Department of State liaison meeting with AILA. And essentially, there's only 64 embassies processing NIVs, and those are at low pace. So if you've got an H, L, O, E, all this kind of stuff, good luck trying to get that approved. And so some countries are, but it's a big question. Will they be accepting people? What's going on? I've asked this, and everyone's wondering, could we do third-party processing, third country nationals, TNC kind of processing? Every country has certain limitations. Mexico had one where it's like they only do extensions but not a new one. But be mindful, if you're going to do one of these appointment-based NIV cases, non-immigrant visas, the person might not be able to get the visa. Like I had one guy who wanted to leave to get a visa. I said, don't leave. I'm not sure if you'll be able to come back in. And sure enough, he has scheduled an appointment, and then the embassy cancel a lot. They frequently do that. They'll even schedule the appointment, and then when it gets closer to the date, they'll cancel it. And so imagine if you left expecting the interview to happen, and then nope, sorry, canceled. Or even they'll schedule the interview, you'll go to the interview, and they'll say, well, your case is good, but we can't issue a visa at this time. You're like, what the hell? So they just wasted your time right there. So be very careful about that kind of stuff. Now, going back to what I talked about earlier about the I-130, try to expedite, try to do for a gentleman who had cancer. I should probably organize these so they go together. I have a deferred action case where the person has a very, very, very sick grandmother. We got documentation. We did an emergency advance parole for it. The manager at the local field office didn't accept it. They said, no, they just have a cough, even though they're dying pretty much in the paperwork. It was very frustrating that they said that. But they're like, you know what? Do an expedite request, mail a DACA application, I-131, to USCIS directly on the front page, say attention manager, write expedite, all this kind of stuff, and send that in to them. And they'll look at it and they'll do it. I said, okay. So we did that. We don't hear anything for a month. So I called them up. I request an expedite. And then a few days later, I get a response that says, USCIS does not expedite DACA advanced parole cases. As a policy, they don't do that. I'm not sure if that's true or not, but then I was at the USCIS ombudsman call of 2 or 3 days ago, and they asked this question there. They confirmed that for DACA, you can't do expedited a request for an advanced parole. So be prepared for that. If you have clients that do it, that's the issue. Now, DACA requests, they're pretty good on the timing of them, and people are saying they are getting them approved even without the best facts in a timely fashion. So hopefully that happens. I mean, this person's grandma's dying. They won't let him go and visit quickly or expedite fast. So hopefully they'll live. I mean, they'll give advanced parole to visit the funeral, but I mean, it's pretty morbid what I'm saying, but it's kind of just the ridiculousness of how this policy works. But that's there. Now I was talking I have office hours for people that are part of my training course for marriage immigration cases, and one of the colleagues asked, like, do you ever do expedite, like written on there? And then several times I've done requests where we send out application and write Expedite everywhere on the front page, last page. I've never had to have the 3 or 4 times they didn't do anything. I always have to get the receipt number, then call them to do it. And for receipt number, to make it faster, we do the G1145 so that we get the text or email of their case number faster. I send it to the client so I know whose case it is. But what I have seen is once they email you or text you the case number, it's going to still take a day or two for their system to update. So I've called immediately after getting it. It's like, we're not in the system still, even though they sent the client the case number. You might have to wait a day or two on that. All right, the last thing we're talking about is N-470, something very rarely people will do, although clients always think it's something they could do. N-470 is if a client's a green card holder and they have to leave for work for a company that's, it could be different things. For the U.S. government, it could be for a company that's promoting U.S. trade overseas, that's an American company, this and that. It's hard getting all this stuff together. So every time I had a consultation on this, it wouldn't work. And the idea is that even though you're outside, a counselor's physical presence, I think. But the big thing to be mindful of is 8 CFR 316.5D. One is the ownership is based on the nationality of the owners of the company. So like I had one case where this guy, a green card holder, owned the company and his subsidiaries company is overseas going to work for it. I said, no, they look at the company, although it's registered in the US, the owner is you as 51% owner, you're a foreign person, so that would have worked. But more importantly, and it's really tricky, to be able to do the N-470, you have to have had previous to filing 1 full continuous year, 365 days of presence in the United States. Now, we deal with immigrants, if you have to go back and forth. So to have a full 1 year of time in the United States without a trip to Canada or Mexico for a day or something like that is going to be near impossible in itself. So even if clients are working for a company that's appropriate for this, all this kind of stuff, you got to get their travel history. And if they don't have a full 1 year in the United States without gap, then they can't use the N-470. It's a really weird requirement they have. It's actually, I think, part of the INA, the Immigration Nationality Act. That'd be one of those things I want to change because that's too strict. So it is what it is, but that's that. I hope all this information helped you. Check out the Immigration Lawyers Toolbox magazine, issue number 2 out, the best trade magazine out there, all of them, because you can't believe how much information is in there, how much helpful colleagues are. If you're starting or if you've already been in this game for a long time, it's going to help you. The next issue is going to be just focused on O1As. If we have 20 people writing articles, if we get enough, it's always a scramble last second to get everything in. But I want to thank everyone who contributed and the sponsors as well. Definitely check it out. Support the trade magazine so we can continue doing this and get bigger and better. Maybe do conferences later, maybe make it a monthly, and to support and promote people who are in this immigration game who can't go speak at conferences but want to get the name out and to help the community become better immigration lawyers. With that, God bless everybody. I'll see you soon. Until then, bye-bye.